Hey everybody, Sam with Mesa bringing you another video update on the eviction moratorium regulations and laws in the state of California, how that affects landlords, what does the future look like for landlords in California as far as being able to collect unpaid rent and processing evictions and gaining possession of a property back. We're going to cover all of it. This is an update to a video that I did on Friday, August 28th, in which I did tell you that things might change because they change what seems like on a daily basis. And then we go through the weekend, and Monday, here we go. We got a brand new law signed by Gavin Newsom on Monday just before midnight, and that is AB 3088, which has effectively taken the bill that we talked about on Friday, AB 1436, off the table. This is the new thing, and it's not speculation. It's not in the works. It's here. It's signed. It's in effect. So we're going to talk about it. It's worth noting that the federal government, via the CDC really, gave an order that halted evictions nationwide through the end of the year. So there's a lot of confusion about, do I go off of the nationwide thing or do I go off of the California one? And Gavin Newsom did a press conference yesterday in which he addressed that. And according to Gavin Newsom, he did say that because the California guidelines are more restrictive than the federal guidelines do not apply in the state of California. Again, that is according to the governor himself. I am not an attorney. I am a landlord myself and property manager for several hundred property owners in Southern California. So I follow this stuff very carefully. This is my interpretation of the laws as I have read them. I read both the nationwide and the state-specific rules in detail several times over. And so I'm only going to focus on 3088, which again is the California-specific eviction moratorium in this video, because the federal ones, again, according to Gavin Newsom, are not in effect. So everything that you thought you knew, let's learn it all again because it's all changed. AB 3088, it went into effect on Monday, and it essentially provides eviction protection for tenants who are unable to pay rent due to COVID-19. So there's really two ways that we have to look at this. We need to look at the past, because what's happened since March, when the original state of emergency and pandemic was declared, up until August 31st, and then what happens from September 1st through the end of the year and beyond. So looking back between March 1st and August 31st, if you have a tenant that did not pay rent, everybody is familiar under normal circumstances with a 3-day notice to pay rent or quit. That has been changed by this law to a 15-day notice, excluding weekends and holidays, to demand that rent from a tenant. So if it's COVID-19 rent, rent that they were unable to pay due to COVID-19 from March until August, you are supposed to serve them, according to this law, with a 15-day notice to pay rent, quit, or declare COVID. So it's a 3-option notice now, as opposed to the original 2-option notice, which was either pay or get out. And you also, with that 15-day notice, have to give the tenant a form that is blank that they can fill out that is a declaration of hardship due to COVID-19. If they fill that out and give it back to you, then that is sufficient. It's under penalty of perjury. And if they fill it out and they say, I've been affected by COVID and I am unable to pay the rent, then you have to take that. That's good enough. And you can require that they prove it if they make 130% of the median income for the county, and that number cannot be less than $100,000. So for most counties, if they make more than $100,000, they are supposed to provide proof, but you can't ask your tenants that are unable to pay rent to give you proof of their current income so you can see it, just so you can see if they make $100,000. You need to go back to when you originally qualified that tenant, and if you have something that says proof that they were making over $100,000, that could be pay stubs, W-2, tax returns, whatever you used to verify their income when they originally moved in. If that's $100,000 or more, and again, it has to be 130% of the median income as well, then you can require that they provide proof. But you can't go asking all your tenants who tell you that they can't pay rent due to COVID to give me proof, or I just want to see if you make $100,000 or more. Can't do that. So keep that in mind. So that covers the past, and you are never going to be able to evict on that rent if they fill out that form. So that unpaid balance that they have, and it's possible that you have a tenant that hasn't paid anything since March, will be converted to a consumer debt. So you're not going to be able to evict them on that. And starting on March 1st, you can file a small claims lawsuit against your tenant to try and recover that unpaid rent. But again, you will never, ever be able to evict on that unpaid balance for that period of time. The small claims normal limit has been lifted, so if your tenant has accrued a balance that is greater than the normal small claims cutoff amount, you are going to be able to sue them for whatever that amount is. They've lifted that for landlords, which I guess it's something, right? That's nice. So now let's look going forward. So you got September 1st through January 31st, 2021. Now, the 3-day notice is still a 15-day notice for this period of time as well. So going forward, if you have tenants that don't pay rent, you don't serve them a 3-day, you serve them a 15-day notice, and it has to have specific language in there, just like the one from March to August did, that is from the law, directly out of the law. This is a notice from the state of California that blah, blah, blah. That's got to be in there. Again, it excludes weekends and holidays, and you have to give them that form that allows them to declare that they have been affected by COVID, and that's why they are unable to pay rent because they've had a reduction in income or whatever their case is. And then they have until January 31st to pay you at least 25% of the rent that's due from September to January 31st, 2021. That does not mean 25% of rent every month as it comes due. That just means that whatever your total rent is from September to January 31st, 2021, they have to pay at least 25% of that in order to continue to be protected from eviction under this current law. So the big question is, well, what's going to happen in January 31st? And my assumption, I mean, based on watching what they did from March up until now, is they'll extend it. Something else will come out. It's hard to imagine that come January 31st, there's just going to be suddenly mass evictions for people that didn't pay 25%. I don't know. Now, for that other 75% or whatever portion they don't pay from September to January 31st, it's the exact same thing as March to August. You're not going to be able to evict on it. They paid the 25%. They're good. Consumer debt, go sue them in small claims if you want to go after them for that. So that's how the eviction portion of it works. There's a couple other provisions in there as well. Most notably, if you remember back to AB 1482, which is the rent control and just cause law that went into effect on January 1st, 2020, there are just cause reasons of why or you can evict a tenant. So there's at fault just cause and no fault just cause. And that is all covered in great detail in the law itself and also on our blog at mesaproperties.net. So feel free to check that out. You have to have a reason to evict your tenant for reasons other than non-payment of rent. So just to kick them out, right? If you want to give them a 30, a 60-day, a 90-day notice, whatever, to vacate, you have to have just cause reason in order to do that. You can't just go kicking your tenants out for no reason, and you need to be listing that on whatever notice you give them that they need to vacate. So that's another part of this law. So you may be asking yourself, well, what if my tenant doesn't give me the 15-day notice back? Can I evict them? The answer appears to be yes. However, that can't happen before October 5th, 2020. You should be able to evict them if they don't do that. But the law does say that if they forgot about the notice, or if it was accidental, there was a surprise or some kind of accidental neglect, then the judge could say, hey, you're still protected under this law, even if they don't return you that form within 15 days. And again, it's not really 15 days because it's 15 days plus weekends plus holidays. We got Labor Day coming up. So those days don't count. Any judicial holidays are not going to count in the counting of those 15 days. Another question that a lot of people have is, well, what about evictions due to something other than non-payment of rent? And unless there's a city, local, some other kind of ordinance that's preventing that, it doesn't seem like there's anything that should keep you from being able to do that. So if you want to evict for a nuisance or something else that's going on, unless there's a local thing that's preventing you from doing that, you should be okay to do it. This AB 3088 really just covered non-payment of rent due to COVID-19. So there is a lot going on. There's a lot to know. Please go ahead and subscribe to this channel. You can visit our website at mesaproperties.net. Check out our blog. We do tons of informational videos and posts like this to bring you as much information as we have. Again, we are not attorneys. This is not meant to be legal advice in any way. Just bringing you the information as we see it. And I'm sure there will be more to come, so stay tuned.